Good afternoon, everyone. I'm delighted to have a chance to be here and talk to you today to give you a glimpse of what the copyright community is buzzing about these days, and that is the impact of the current iterations of generative AI. And this exciting new technology raises very important copyright issues. And you might ask why, if you're not deeply immersed in the field. It works by ingesting numerous copyrighted works and then producing content, art and music and text that resembles content produced by human authors. And it can also be used to produce realistic replicas of humans' appearances and voices. So the question is, how does all of this fit into or require changes to the existing copyright system? Now, there's some very fundamental questions here. How does human creativity differ in nature from what AI systems can generate? And that is either now or in the future. In what ways can the technology serve as a valuable tool to amplify human creativity and ultimately promote progress? To what extent might AI-generated content replace human-authored content, essentially drown it out, and reduce incentives for humans to create? And ultimately, how do we avoid impeding technological development while also ensuring that human creativity continues to thrive? So, looking at all this, the Copyright Office launched a comprehensive initiative to examine all of these questions. And in our role administering the Copyright Act, we began by issuing guidance in March 2023 on how to register works that incorporate AI-generated content. So we confirmed that human authorship is required for copyright protection, and we told applicants to exclude from the scope of their claims in the application any AI-generated content that was separable and more than minimal. And then later that year, we issued a notice of inquiry seeking public comment on the full range of issues raised and ended up getting more than 10,000 responses, all of which we have read and analyzed. And I always get asked whether we used AI to do that, and the answer is no, not yet, maybe someday. And in July, we published the first part of what will be 3 parts of the report that came out of that notice. And this was on the topic of digital replicas or deep fakes, as some of you will have heard earlier today from Andrew Foglia of my office. Now, as everyone's aware, there's been really a proliferation in the use of individuals' images and voices that make it look like they're saying or doing something that they're not. And we've seen that in the political space, we've seen it in advertising, we've seen it in pornography. And although the technology to produce fake images and voices has been available for a long time, AI technology has made doing so easy at tremendous speed and scale and with more sophisticated and perfect outputs. And the harms that can be caused are both immediate and obvious. So an individual's image and reputation can be damaged, and income can be diverted, and public trust can be eroded. How do we know that what we see is what it looks like? So in our report, we surveyed existing law, both state and federal level, and concluded that they did not adequately deal with today's threats, that there were a lot of gaps, and it was an incomplete patchwork. So we found that there was an urgent need for a new federal right protecting all individuals, not just celebrities, from the unauthorized use of their likeness and voice, whether for a commercial purpose or not. And Congress, at the same time, has been looking at these issues. So on the very same day that we issued our report, hours later, a bill was introduced in the Senate called the No Fakes Act. Don't ask me what the acronym stands for, but it is an acronym. And it would establish a property right in an individual's voice and likeness. And a companion bill was introduced in the House shortly thereafter. Now, the provisions in this bill are consistent with most of the recommendations in the office's report. And we expect that these bills will be reintroduced in the new Congress, and they do have considerable support. So hopefully they will move forward. Several states are also considering or have enacted laws dealing with unauthorized digital replicas, in particular California and Tennessee, not surprisingly. And in Tennessee, it's called the Elvis Act. And that adds yet another nuance, which is how does the state law interact with any new federal law? So that's the digital replica issue. The second part of our report was released about 2 weeks ago, and that's on the topic of the copyrightability of the output created using generative AI. Now, in this report, we tried to clarify how the standards of copyrightability apply in this context, and also to allay concerns about humans being able to use AI as part of their creative process. And again, we began with the principle that human authorship is required for copyright protection. And that's not just our preference, that is based on the Constitution and the Copyright Act and more than a century of judicial interpretation. But that's, of course, just the starting point, because there is almost always, you might even say always, but I never want to go out on a limb too far, but there's almost always some level of human involvement in producing AI content. And ultimately, the question is always going to be whether the traditional elements of expressive authorship in the output were determined by a human or by the machine. Now, the policy implications here are significant. This isn't just a technical question. Many commenters pointed out that given the speed at which AI systems can produce material, there's a risk that floods of what is essentially derivative content could drown out more creative human works. And that could have serious consequences for human authors' livelihoods and the evolution of culture. And at the same time, we are aware that AI is increasingly being used by artists in various mediums to augment their creative process, and we want to encourage that type of innovation. So with all of that in mind, in our report, the office drew the following conclusions. The use of AI as a tool to assist in the process of creation, or the inclusion of some AI-generated material in a larger human-created work doesn't affect the availability of copyright protection, still fully copyrightable. As to the outputs of generative AI, they can be protected by copyright only where a human author has determined sufficient expressive elements in that output. And that could include the situation where a human-authored work is perceptible in an AI output, or where a human makes creative arrangements or modifications of the AI output. But, we said, copyright does not extend to purely AI-generated material, or material where there is insufficient human control over the expressive elements in the output. And based on the functioning of current generally available technology, the mere provision of prompts does not in itself provide sufficient human control. We also concluded that the case has not been made to change the law to provide additional copyright or other forms of legal protection for AI-generated content. And we're going to continue to monitor what's happening. There's very fast-paced technological developments, very fast-paced legal developments, and we made very clear in the report that it is possible that as any of these things move forward, we might be revisiting these conclusions. So in the coming months, we're going to be issuing the final part of the report on the topic of the ingestion of copyrighted works, and that's the most controversial of our topics and the subject of now dozens of pending lawsuits. So just to summarize the competing positions, copyright owners say it can't be fair for the fruit of a lifetime of education and skill and inspiration to be used as raw material to produce works that compete with them in the marketplace. But on the other hand, AI companies and their customers say that licensing isn't feasible given the variety and volume of the works that are needed for AI training, and copyright shouldn't block the development of what could be extraordinary technological advances. Now, most commenters in our inquiry told us that existing law suffices to address this question. They disagreed strongly, though, on its interpretation, primarily on how the copyright fair use doctrine applies. So there's one line of cases that's held that the internal copying of a mass number of entire works for purposes of research and analysis is fair use. But the Supreme Court's recent decision in Warhol versus Goldsmith emphasized the impact of the ultimate use on the actual and potential market for the copyrighted work. Now, the courts are going to be grappling with the application of fair use on a case-by-case basis based on these specific facts presented. And in fact, there was just a report this morning of an initial decision in one of the pending cases. Hopefully, our report can serve to shed some light on the analysis. So let me actually conclude with 2 points. One is that we are also about to issue a publication from our Chief Economist's office, which will be a paper setting out a proposed framework for research on the economic aspects of AI and copyright. We'll also be updating our guidance to applicants and our compendium of Copyright Office practices. And then finally, I just want to note the value of international dialogue on these issues. Other countries are also considering all of the same things. And while identical approaches are unlikely, some level of consistency will contribute to smooth global commerce. And we're therefore communicating with our colleagues, with our counterparts elsewhere, and sharing ideas and experiences. And I'd say so far, some areas of consensus are clearly emerging, but also some potential differences, at least on paper. But these are early days. It remains to be seen what conclusions countries will reach or how far approaches may diverge in practice. And while we all share the same goal of balance and all have creative communities to nurture, at the same time, there's a backdrop of strong competition in the innovation space. So I'll stop here, and if there's time, I'm happy to answer questions. If there are any questions. No questions? Yes.
What was the case that preliminary decision today?
I don't have the site in front of me. It involved Lexis and Westlaw, and the question, and the court said that that particular use was not fair use on a preliminary injunction basis, but also stressed the fact that this was not actually generative AI. So we're still looking at and parsing the decision. It was just a few hours ago.
Okay.
Yes.
Hi. So it seems like often, my name is Courtney Raj, I'm with Open Markets Institute. It seems like these conversations around AI and copyright often take place in a bubble, divorced from concepts around the public interest, which is at the root of copyright law, but also questions around competition and competition policy and what's happening in the AI space, where we see a lot of the dominance of big tech firms continuing in the AI space, which is undermining innovation. So how are you thinking about the link, if at all, between what your office decides on AI copyright inputs and what's that going to do to the competitive landscape, including the fact that, training AI data on other AI-generated data currently leads to model collapse and also to economic collapse of human industries such as journalism, such as the creative industries?
Mm-hmm. Yeah, that's a very good question. We do try to, well, on the one hand, obviously we have to remain aware that our bailiwick is copyright and we're not experts in fields like antitrust law. At the same time, we do try to stay cognizant of everything that's happening, and we do talk to and communicate with other agencies that are working on AI issues. And there are ways in which copyright law can take into account at least some aspects of those policy matters. For example, in the fair use analysis, where you look at impact on markets, and then you can consider other factors besides the ones that are explicitly laid out in the statute. But I think you do make a good point, which is, copyright can have impacts in other areas, and other impacts can have impacts on copyright. And especially in the AI space, it does seem like there's a lot of overlap these days.